Topic 1 is the leave of absence. As far as the leave of absence is concerned, justices, we say the following. As I've already said, the President does not have the power to place a minister on leave of absence, full stop. All the parties, fortunately, agree that there is no such express power, that nobody has to go there. So the best case for the other side would be to rely on some kind of implied power, because we all agree that it's not there. If it was, we would all see it. And we'll demonstrate that on the test put by this case, rather by this court with respect, in Amabungane by Madlanga J, and as complemented in Mwabe by Majid J. On that test, which in any event is an accepted test, the test of necessity, you cannot have an implied power unless that power is necessary to exercise the one that is primary. That's just as simple as that. Sorry. If I may. Just express that proposition. Hoekstra, in the latest book on admin law, expresses the test of necessity beautifully as following. Starts by re-expressing feature. It's consonant with the principle that repositories of power can only exercise such power as has been conferred on them by law. Implied powers may, however, be ancillary to the express power or exist as a necessary, and that's where the test is, or reasonable consequence of the express power. And this is the beautiful example she gives. Just as the power to make omelets must necessarily include a power to break eggs, so the power to build a dam may include the power to expropriate property or to remove silt. And then she makes other examples. In other words, for an implied power to arise, it must be a necessary concomitant of the primary power, the one that has been expressed. So how do we bring that home here? You would have to find a formulation, absurd as this might sound, that says that the power to dismiss, for the power to dismiss to exist, it is necessary in the legal sense that you must also have the power to place a minister on leave of absence.